the new avatar of IPC. The other is that it is more, I think, digital savvy. It, I think, it can be used more and more effectively in the present times where computer has become virtually something like a hanky or a purse that we keep and we use very often. So I would say it's a very computer savvy law. One very unique feature which is there in the new criminal law, especially the new avatar of IPC, is that for the first time the definition of punishment has been enhanced and widened to include community service. Though I expected that it should have been included for money mode section, but it has been included for a very minor and just one or two sections offences. Because community service is one kind of punishment which is in vogue in various countries of the world. I think that is the way forward. Because if you when you punish somebody, um, you take away something from him. Now he does not get a time or opportunity to reform himself. Community service is a punishment where he gets to mingle with the society, gets to be a part of the society while being a convict and improving himself. So this community service, I would request all the community, all the members of the bar, and if you can press upon your representatives of in the legislature, that they should include this community service as a punishment in various other offences. It can be exclusively community service, or it can be community service as an alternative to other punishments like fine or imprisonment. They are more comprehensive, all of them, though the concepts which were there earlier in Evidence Act, CRPC and IPC are probably 90 to 90%, 5% are the same. And my experience is that I always, whenever a bail application comes to me, so I always ask the old section because it is there in my mind. So I have to find the equivalent of the new section, and since I'm entering the old age, I'm almost 60 now, so it's difficult to accept and imbibe in you the new laws. But then I'm trying hard, and I hope I'll succeed with your assistance. So today I think we should congratulate Mr. Khandelwal for bringing out such a big, nice publication forwarded by none other than Honorable Justice Mittal, who was our Chief Justice in Madhya Pradesh, and he had a very good tenure there. And from whatever I get from him, he has really enjoyed the tenure there in Madhya Pradesh. Though it was not a very long one, but about one year, but he has really thoroughly enjoyed it. And we have learnt a lot from him. I would just like to say a few words about this series which has begun. Last time, in the last week, I think Justice Bangar was here in regard to some revenue laws. So I hope you have learnt from him. And the last time also I had said that you should not remain a silent spectator when these lectures are being held. You should actively participate, ask questions, because that is the only way you can improve your knowledge bank. We are always in the process of learning. Even anybody in this world is in the process of learning, and the learning never finishes. Even your death never finishes the learning. So try to ask questions and learn as much as possible from the opportunity that you're getting. Every week we are organizing lectures on some topic which is given by the Bar Association, and whatever topic is difficult for you to understand, please give those topics, and we'll send whichever sitting judge it is as per his convenience, and we'll hold those lectures for half an hour, 1 hour, whatever. And if you want, I will anytime come up and be a part of that. Thank you.
I invite Honorable Mr. Justice Rishi Thakur to address the members of the bar on a topic of speedy trial. And speedy justice also. Okay. The Honorable Chief Justice of the High Court, Mr. SINGH, the other Honorable Judges who are present here, the President of the Punjab and Haryana High Court Bar Association, the Secretary of the Punjab and Haryana High Court Bar Association, the Joint Secretary, Madam Daya, and all the learned members of this esteemed Bar Association. It's really a pioneering move on the part of the Honorable Chief Justice to, on a weekly basis, hold interactions with you. That definitely reduces the distance between the bar and the bench. The distance is immensely hard because you're sitting on the dais in the gas in the courtrooms, and here we are both, all of us on the floor of the bar. Now, since you address us in the courts, now you have given us an opportunity to address you here, but your addresses in the courtrooms are the nature of very heated advocacies, but here we will not be given an opportunity, being all of you such learned advocates, that we have to advocate the cause of the bench before you. But since the issue, which is of burning importance, relates to speedy trials and speedy justice, thereby is the initiative which has been taken by the Honorable Chief Justice to enhance his skills and knowledge is of importance. The reason for the importance of this pioneering initiative being taken by the Honorable Chief Justice is that enhancement of knowledge reduces the time for understanding, brings equity of understanding, and thereby reduces the time which is consumed in yours making submissions before courts of law. The lesser the understanding of any subject of law, the more prolonged duration of times are consumed by counsels, as well as by the bar bench also, because we are also deficit in knowledge. And if longer times are consumed, thereby there is prolongation in the justice dispensation system. If there are prolongations in the justice dispensation system because of lack of understandings on part of the bar and the bench, the casualty is always the litigant. The casualty which befalls the litigant on delayed justice being given to the litigant does get aroused from the fact that because of immensity of time becoming taken by the counsels to address arguments, thereby with increased dockets with the courts of law, those who are in the queue, they are deprived of an opportunity to access justice and receive justice from courts of law. Therefore, there is required to be reduction in times which are consumed by the counsels to address arguments. The said reduction would definitely ensue in case the pioneering initiative made by the Honorable Chief Justice makes further headways, whereby both all of you participate, increase your knowledge not only on the floor of this barroom, but otherwise also under the mentorship of your junior, of your seniors, and also constantly persevering to ever enhance your knowledge. Ensure that as in school, all of you were asked to make précis of long didactic thesis or stories or any subject, the same way advocacy is required to be. Be precise. My request and imploration to all the councils here, all the men of the bar, that thereby the cause of justice will be served. There's a cry for early decision making by courts of law. The reasons for delays are so many, including the one on which I have already dilated upon. Maybe because of the inadequacy of judges on the benches, maybe because there is there are orders of an interim nature which are passed and which whose effect will be curbed in case the decision is made on the list. Therefore, the obviously the litigant who has been yielding the benefit of any interim order, which is likely to be vacated because the councils know the strength of their cases. There will be always an attempt to prolong the making of a decision on any list. That kind of an endeavor, though may promote advocacy, though may serve a litigant, but it does not serve the cause of justice. The cause of justice is higher and paramount, and its requirement has to deeply etch in the mindset of the legal fraternity. The legal fraternity is not only the advocates, they are the members they're the judges on the bench, they're also the litigants. The headways towards each of us aspiring that to the utmost efforts we painstakingly make, we somehow or the other curb the tendencies of litigation before us, as thereby we serve the cause of justice and serve the nation. The institution of the judiciary is a very coveted and pristine institution. The manifold of powers which are vested in the High Court and more especially in the Chief Justice, who is the master of the roster, does bestow a most credit-worthy and privileged position to the Honorable Chief Justice. He has to, as he's always been doing with his pioneering efforts, reshaping the color and complexion of the judicial infrastructure in all ramifications with his own independent and well-thought contemplations. You have to ensure that you join hands with the Honorable Chief Justice in his well endeavor to ensure that justice is done to all. On the administrative side, also the Honorable Chief Justice has taken immense strides in ensuring that to the lowest of the persons in the hierarchy of the High Court establishment, justice is done. And that is an extremely laudable effort. In a very short time, he has earned a niche for himself in the annals of history of the High Court of Punjab and Haryana. And we claim his efforts. The tryst with the establishment of the Punjab and High Court began after this dismemberment of the country into two halves, Pakistan and India. Originally, the seat of the Punjab and Haryana High Court was at Lahore, but post-partition, the seat of the Punjab and Haryana High Court was established at Simla. Therefore, the basis and the origin of this principal seat of the Punjab and Haryana High Court is at Simla, and subsequently, the seat of the Punjab and High Court was established at Chandigarh, which is a newer city than Simla, which was otherwise also the summer capital of the British. Well, that is history relating to these Punjab and Haryana High Court. However, we are still concerned with the fact that you have to help all of us, the Chief Justice and all the brother judges, ensuring the access to justice of all the litigants. The stockpile of litigations, the stockpile of the areas of cases which are required to be liquidated is immense, whether it be in the High Court or be in the trial courts. The trial courts are overburdened, and there are initiatives being taken by the Honorable Chief Justice to, through creation of better court infrastructures, better residences for the judges who are to man the courts, that as such they are well equipped to handle the heavy docket of cases which are already there and which would ever pile up. Though there are bifurcations of jurisdictions through creation of so many tribunals, but yet that is not decimated and has not fully served the purpose of there being a requirement of endowment of speedy and effective justice to all the litigants, whether they be at any tribunals or any other quasi-judicial fora, more especially the trial courts. Now, the effect of lack of speedy justice has ultimately led the Honorable Apex Court to, especially in cases where stringent punishments are required to be imposed upon heinous offences, to on delay of trials taking place to release. Therefore, all the more dire requirement arises that the counsels and the trial courts who may benefit from lack of speedy trials becoming embarked upon by the trial courts to not take to their advantage through asking for impermissible adjournments, that thereby they would ultimately avail the benefit of such delays in the making of trials. The purpose of penology is twofold. It serves society as well as justice is to be done to the accused. Therefore, in respect of heinous offences where the interests of society, the interests of victim are also well entrenched, there is a requirement much heavier upon the trial judges to ensure that there are no uncalled for adjournments, so that ultimately even the counsels have an onerous obligation in that regard, that as such the counsels do not reap the benefits of so many verdicts delivered by the Honorable Apex Court, that delays in making of trials would result in non-ensuring of abidance being made to Article 21, and all thereby that's being want of speedy justice and ultimately leading to indulgence of bail being granted to the accused. Full stop. Sorry. I think I got back my mindset, got back to the it's not a judgment. It was just I was on the. No. It is for you to think that whether it's important or not. But I got so absorbed in the thinking process. The the strength of the bar is not adequate to the space which is available today. Though at times we find that this courtroom of the Honorable Chief Justice is packed. So we always expect that we come to the floor of the Bar Association, we also have to show the same enthusiasm. Semi-packed bar room does not really augur well. You have to show better enthusiasm. So hopefully, when in the ensuing week, the Honorable Chief Justice, along with another judge who's adapted by him for this occasion, you should have a full house as you pack the courtrooms for relief. So at this moment, you have to also pack the bar room. Though at this stage we cannot give you relief, but at least we should give an opportunity to also make some kind of advocacy before you. So So anything which is required to be added or supplemented, some evocations which may ensue from the members of the bar, they are invited, and if possible, we shall respond. You see, speedy trial is trials of criminal appeals, trial of civil suits continue even to the appellate stage. Now I reiterate that frivolous applications should not additional evidence. Even during execution, there are applications to delay executions. Those are stock instances of frivolous attempts being made to defeat the cause of speedy justice. Now you see, I said at the initial stage, learned counsel, when you are on the floor of the court, you are on the attacking board, and we are on the receiving. Today we are on the floor of the bar room, and therefore you have to also endow to us the same privilege as we endow to you when you are on the floor of the court. Yes, yes. Isn't it? We are maintaining balance. That's why the Honorable Chief Justice thought that we should also be given an opportunity to the floor of the bar room to advocate our point of view before you. That enhances bar and bench relation, reduces the distance, creates more empathy between the bar and the bench, which is much required. There should be no strained relationship. There should be no misconceptions. We are here to serve the cause of justice from within the hallowed precincts of the High Court. You be assured about that. And any misunderstanding of any nature, the Honorable Chief Justice is always open to receive your. Yes. Yes. Advocacy, speech also.
But sometimes to satisfy the client who is sitting at the back.
Yeah. So that is, yes.
Honorable judges refuse to
Yes.
listen and elaborate.
You see, now your responsibility is never towards your litigant as it is to the seat of justice, as it is to your soul. The soul is the. Please sit, learned counsel. You are not in the court. You are on. You presuppose that now you are on the DS. And we are addressing the court. So the seat of justice is like the seat of the soul within you. Each counsel is supposed to having that well-seated soul. Inspiration to advocacy, to good advocacy is the outpourings of the soul. If all of you are conscientious lawyers, all of you, as I said, know the strength of your case. Therefore, you're answerable as the benches to their respective souls, to none other. The litigants behind you, they are not supposed to be instructing you to the extent that you argue against settled positions. You misplead, you raise frivolous pleadings. Through some endeavor or the other, try to delay your, as responsible citizens, you have to assist courts of law in doing justice to everybody to reduce the pain of injustice. That's a very hard task. Requires day-to-day introspection, day-to-day inner thinkings, and ultimately the outpourings. Reformation has also got to take place. If each of us reforms ourselves, we'll be leading towards better civilization, reducing anarchy, because we are, as on the DS, we are endowed with the constitutional jurisdiction of corrective judicial mechanism of executive arbitrariness. And you have to aid us. Not that you have to take a standpoint that the executive is always brazenly arbitrary. Not to arouse the sentiments of the court to the extent that you make the court feel that the executive has to be always lambasted. There has to be balance every time, in every case, every moment. That has to be a endeavor which has to be a lifelong endeavor. And that is how we'll be able to serve the cause of justice. That's how we'll be able to reduce the docket of, heavy docket of cases which are before the High Court, before the trial courts. That is how the pain of injustice will be alleviated. Of course, one or the other litigant has to suffer loss, but that if those scales of justice are loaded against a particular litigant, the counsels, if they know that as a matter of fact, this certainty of judicial procedure, the certainty of the exposition of law with precision applied to similar set of facts would result in the same judicial decision. Thereby it is known to the counsels. There has not got to be repetitiveness of arguments on certain settled expositions of law, which are to be throughout applied in a similar fashion to the same set of facts. Still, there is an argument, except when there is need for distinguishing, a need that the judgment is imperial. Maybe to that extent, the counsel have to accept that they have to bow down to defeat, humbly accept defeat. One has to succeed, other has to lose. But the touchstone of advocacy is conscientious advocacy. The touchstone of good decision making is conscientious decision making. That is how justice is done, and ensure the quickening of the pace of judicial dispensing by the High Courts under the leadership of the Honorable Chief Justice, Justice Nagu, through yours, ensuring that you reduce the time which you consume in courts, lesser of filibuster, more of precise arguments. My request to all of you. Thank you very much. Very good evening.
May I invite Honorable Mr. Justice Ajay Kumar Mitra, former Chief Justice, Madhya Pradesh High Court, to address the members of the bar.
Honorable Justice Shri Nagu, Chief Justice Punjab and Haryana High Court, esteemed colleagues and distinguished members of the legal community. Today we have gathered on the release of three seminal texts. This is book and commentary on the Bharatiya Nyaya Sanhita, book on the Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Suraksha Sakshya Adhiniyam by Justice Shri Nagu, Chief Justice of Punjab and Haryana High Court. These texts, authored by Dr. K.K. Khandelwal, Mr. Ravindra Khandelwal, Mr. Kavaljeet Dahiya, Madam Anu Singh, and Mr. Varun Chuk, represent a transformative shift in our legal paradigm. In a landmark move, India has undertaken a sweeping overhaul of its criminal justice system with the introduction of three pivotal laws: the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. Having gone into effect from July 1, 2024, these new laws replace the colonial era Indian Penal Code 1860, the Criminal Procedure Code 1898, and the Indian Evidence Act of 1872, and are poised to bring significant reforms aimed at modernizing and streamlining the country's legal framework. These reforms are not just cosmetic update, but a comprehensive reworking of India's criminal laws to better align with contemporary realities. The new laws aim to address the long-standing inefficiencies and inadequacies of the existing statutes, which have been criticized for being outdated and unresponsive to the needs of modern society. The drive for these changes was fueled by the necessity to enhance legal procedures, integrate technological advancements, and ensure a more robust protection of citizens' rights. The Bharatiya Nyaya Sanhita focuses on substantive criminal law, aiming to simplify and update the legal provisions to reflect current societal values and technological advancements. The Bharatiya Nagrik Suraksha Sanhita overall procedural aspects, ensuring quicker and more efficient justice delivery. Meanwhile, The Bharatiya Sakshya Adhiniyam modernizes the rules of evidence to include digital and electronic records, which are increasingly relevant in today's digital era. Three reforms are anticipated to have a profound impact on various sectors, from law enforcement and judiciary to the general public. By introducing measures like digitalization of processes, videography in search and seizure, and forensic science integration, the new laws aim to enhance transparency, accountability, and efficiency within the criminal justice system. New criminal laws also strive to balance the fundamental rights of individuals with the collective security of society. They provide mechanisms to safeguard the innocent while ensuring that offenders are held accountable. For example, recent reforms focus on faster trials, victim compensation, and rehabilitation of offenders, emphasizing both justice and humanity. Laws are not static, they are dynamic tools that reflect the will and aspirations of the people. Public movements and demands often drive legislative changes. The enactment of stricter laws against heinous crimes, such as the Criminal Law Amendment Act of 2013, which followed the Nirbhaya incident, showcases how societal awareness and activism can shape the legal landscape. As we move forward, the enactment of new criminal laws must remain guided by the principles of fairness, equity, and constitutional morality. It is equally crucial to ensure their effective implementation. Merely passing laws is not enough. Educating the public, training law enforcement, and modernizing judicial infrastructure are vital to achieving their objectives. The authors, because today has been the release of these books authored by Dr. K. T. Khandelwal. The authors have meticulously dissected and elucidated the nuanced provisions of these new laws, providing a clear, authoritative guide for practitioners, scholars, and enforcers of the law. The commentary delves deep into the transformative aspects of these laws, discussing the augmented powers and responsibilities endowed upon police officers and the streamlined processes introduced for trials and appeals. Such insights are crucial for law enforcement agencies and judicial officers as they encapsulate the practical implications of the reforms, of offering a forward-looking perspective on the administration of criminal justice in India. The release of these commentaries marks not just the culmination of rigorous scholarly endeavor, but the beginning of a new chapter in the effective application of our criminal laws. These books are poised to become cornerstone references that will guide practitioners through the intricacies of these significant reforms, inspiring and informing the effective application of the new criminal laws and ensuring that the envisioned reforms translate into tangible benefits for the justice delivery system. I thank the organizers for inviting me on this book launch ceremony, and I look forward to the positive changes these texts will bring to our legal landscape. Thank you.
May I invite Honorable Chief Justice and Honorable Justice Vivek Thakur to release the book, namely Comprehensive Study on Punjab Village Common Land Law, authored by Shri G.K. Deer, former District and Session Judge. May I invite Shri Jasdev Singh Brad, Active President, to deliver the vote of thanks.
Good afternoon to all. I urge the youngsters to be here in more numbers next time. Ask your friends to be here. It is turning into a formal session. It should be a informal thing that you ask questions from the topics, taking out from the topics which are spoken here. But For the next time, kindly ask your friends to accompany you. And first, yes,
You should ask the youngsters if they have got any question.
yes,
Thereafter they will ask. No? I've got some suggestions about the speedy trial if I could come.
yes, you can. You always. Next time we get it a point.
Honorable Chief Justice, honorable judges, and my friends. The problem with the speedy trial starts when the report under section 173 CRPC is presented. So in the case non-bailable offence, the accused in custody is produced before the court. But in bailable offence, the challan is presented. The accused are not before the court. So first hurdle starts about the presence of the accused. That hurdle can be curtailed if the investigating officer is asked to produce the accused along with the report 173 CRPC at the time of the presentation of the challan. So that 2-3 dates which are wasted for the presence of the accused, that could be saved. Then comes the stage of the framing of the charge. At that time of charge, we keep consuls file an application for discharge that is to be considered. Thereafter, prosecution evidence comes. Thereafter, a crucial stage comes. We file an application under section 311 CRPC. The trial is held there. The trial court decides the application 311 CRPC. Reply comes, and thereafter another dates and another dates. So there is a system that CRM number should be fixed on 311 applications in the trial court, and the main case should be separated. It should be also that fixed upon evidence. The evidence should be called. It should be recorded side by side, and thereafter 311 application be decided. So it can also curtail the procedure of the trial in criminal cases. And thereafter, once the evidence part is over, thereafter then the defense evidence, there should be specific opportunities. In olden times, when I used to be heard from my grandfather, my great grandfather, they were also advocates before the trial court. They used to say that in sessions trial they used to commerce day by day. Once the charge was framed, thereafter the session trial commerce for a week, 10 days until it's concluded. But nowadays in a trial court, this does not happen. Long dates are given because of the workload, maybe. And thereafter, the defense evidence starts. It should also be a specified that in such and such time there were such dates. The list of defense witnesses should be asked the counsel that he should provide on the at the time of recording a statement under section 313 CRPC. So like this, the criminal trial can be cut short. And likewise, in a civil procedure also, in civil cases, once a suit is filed, thereafter, upon the talbi, the process is prolonged. Though we have given a procedure about the serving of summons through electronic evidence, but that is not being followed in the trial courts there because the Tamilis, the process servers, they do not follow that procedure about the serving of the summons on WhatsApp and the serving of the summons on emails. That should be asked to be effectively followed. And thereafter, the stage comes about the stage of a written statement. Thereafter, before the written statement, we consuls file application under Order 7, Rule 11 CPC for the rejection of the plaint, and thereafter. So there are many aspects for which we can curtail the length of a trial. So normally nowadays 4 or 5 years are curtailed in a civil suit. In a criminal case also 5 years. In session trial cases they take a long such times. So my humble prayer is that they should be curtailed so that some appropriate directions be issued so that justice should be provided to them.
thank you, Mr. Ritu. This is for speedy trial. Anyone for speedy justice? So let's conclude it. Okay. Should I invite you? Okay, Mr. Khandelwal, you want to come on the dais?
Yeah, please.
You want?
Kindly speak some few words, my lord.
Honorable Mr. Justice, Chief Justice Shri Shri Naguji, Honorable Mr. Justice Vishnu Thakur ji, Honorable Mr. Justice Ajay Kumar, Mittal ji, former Chief Justice Madhya Pradesh High Court, and all the dignitaries who are present here along with the bar members. I thank you that you are here, that too after the good timings. I take this opportunity to thank all the bar members here and the distinguished dignitaries to be here. I request you all now to join for the tea and we conclude the session after this. So let's see you next time.